Thank you everyone for joining the webinar today. My name is Michael Hansen, Program Manager at the Action Innovation Network. Action is a collaborative network of technology business incubators and other entrepreneur support organizations located throughout the New England region. Our network supports startups developing technologies across a wide range of tech industry sectors, including life sciences, clean tech, robotics, ocean marine technologies, and advanced materials. Our Plymouth Rock project provides a suite of resources for international startups that are interested in exploring this innovation ecosystem as a place to grow their company in the US. A few items to review before we start the presentation. All attendees will have their audio and video muted. The presentation will run approximately 45 minutes, followed by Q&A. If you have a question for the presenter, please use the chat window to submit your question to the host. This webinar will be recorded and emailed to you and posted on the Action website. Today's webinar, International Considerations When Filing Patents, is presented by Tani Chen, counsel at Wolf Greenfield. Tani counsels clients in IP protection in a wide variety of areas, including batteries and fuel cells, nanotechnology, drug delivery, chemical processes, biomolecular engineering, and analytical devices. He has a particular focus on startups, small businesses, and university work, and has helped companies develop strong IP protection based on their business goals and potential threats from competitors. In addition, Tani has been active in several business competitions in the area, including mentoring teams for the MIT 100K competition and the MIT Enterprise Forum. Tani also has a doctorate in chemical engineering from MIT and a law degree from Suffolk Law. Thank you for presenting today, Tani. We look forward to your presentation.
Great, thank you, Michael. So today we're going to be talking about patents and in particular various considerations internationally when you look at your patent landscape. This is a little bit about my background. Michael has introduced some of these points, but my technical background is actually in chemical engineering, where I received a doctorate from MIT back in 1999. Then I did a postdoc for 2 years at the Harvard Medical School, and then I started at the law firm of Wolf Greenfield, where I've been ever since, practicing in patent law and focusing primarily on early stage technologies, including technologies from startups and universities, generally in the chem or biospace, including energy and some of the other things you see here. So I often like to start these presentations by talking a little bit about, what exactly is intellectual property. And I like to break things down into their constituent parts as an engineer. So if you look at the words, there's 2 words here. There's intellectual and there's property. Intellectual is basically defined as being a bit of an intangible thing. And property is defined in the law generally as a right to exclude. And so this is a little bit of an unusual concept. Most people think of property as something you touch, but in reality, it's generally more as a right to exclude. So if you think about something like personal property or real property is real estate, so it's land, so physical things such as a building, or even if you're not at home, your right to keep other people out of your home doesn't go away, it's still there. And that's why it's really more of a right to exclude rather than where you're actually present. Intellectual property kind of works the same way. It's defined as the right to keep other people from using this intellectual thing that you've developed. And it's still your property right, even though by definition as an intellectual thing, it isn't something that's a physical object like a piece of real estate or a physical thing like a computer. IP breaks down into a number of different areas. The most common ones include the ones you see here. Patents generally exclude the use of an invention. It's the thing that most people in the startup community or early stage technologies or other things are interested in. But it's not the only form of intellectual property out there. Another common one is copyrights. These generally are intended to protect creative works. So these are things like movies and novels and computer programs, sculptures, various things like that. There's also trademark, which is a way to exclude the use of branding. So common brands such as McDonald's for hamburgers or Coca-Cola for soft drinks. these companies have trademarks, which means they can exclude other people from using or copying their mark or their logo or things like that. And another one that's very interesting that people are very interested in are trade secrets, which generally exclude the use of secret ideas that provide value to the company that owns the trade secret. So these are the basic tools, and IP really is a business tool that allows you to develop a business, further your business plans and things like that. It can come into play in a number of different ways, both offensively and defensively. The key one for intellectual property is this idea of blocking other people from doing whatever it is that you want to block them from. Ideally, it covers the market that you're interested in. Of course, you may not necessarily want to exclude people from the market completely, so you might license or sell the IP to others. And there's another of different other ways you can use the IP for, as you can see on the slide here. On the flip side, it also has the same sort of goals, but on a defensive position. One of the more common things that people will do is they might patent things or file IP protection on various things to prevent other people from using those developments or become competitors in a business. And that might be true even if it's something they don't necessarily intend on developing and selling themselves. It might be, for example, an alternative way of doing something. And if you can block other people from doing that, that might give you some sort of competitive value and prevent other people from coming in and taking your market space or things that you care about. So most of this talk is going to be focused mainly on patents and generally how patents work in the US and around the world as well. And I'd like to start this discussion about patents about, what is really a patent? It's basically something that protects an invention, and then that leads to the question of, well, what is actually an invention? So let's talk about that. An invention is generally, as I like to describe it, it's something new that no one else has described before. A couple of things to unpack here. So no one, includes everybody, which includes you. So that means that you can do things that make the thing that you invented no longer patentable because of your actions. And before basically means yesterday and any day before that. So if you do something in the past, that can prevent you from getting an invention of it. The most common thing that people look at when they look at inventions is whether it's new. So new basically means, does anyone else know about it? If people know about it, by definition, it's not new because people know about it. And so things that you do or things that other people do can mean that people know about it, and at least one other person besides you knows about it, such that now it's no longer new and therefore no longer a patentable invention. And there's a variety of things that people can use to determine whether the thing that you've invented is in fact new or just a repeat of something that someone else has done before. Which includes you. So this includes things like articles, presentations, web pages, emails, Facebook pages, LinkedIn pages, just pretty much anything where there's any form of public dissemination can be used to say, well, somebody else already knows about this. Doesn't have to be in English. It doesn't have to be in the US. It can be in other countries, pretty much anything. If someone else has access to it, it's no longer new. The second criteria that you look at is about an invention is it's got to be something that's basically not obvious or somewhat unpredictable. This is a little bit more difficult to define, but generally speaking, the idea here is that patents and the sort of protections that you get are really designed for significant improvements. They're not for minor tweaks, minor changes in dimensions or colors or something like that. It's really meant for significant advances that are worthy of protection. And it's a little hard to define, and oftentimes patent lawyers will do a patent office, and this is sort of the things that they argue about is how significant of an improvement this actually was. The third thing that people look at is whether it's something that's actually useful. This is defined basically as a practical sort of thing, so it's meant to be for technological advances and things of that nature, rather than things such as mathematical formula, which might be very important for various reasons, but don't translate into a practical use, at least right away. And that's a little bit too abstract for it to be considered to be a patent. One of the things I often say with these talks is that if you don't remember anything else about it, the most important thing is that you have to file for patent protection before any form of public disclosure. And if you can remember that and take steps accordingly, consulting with a patent lawyer or something like that, then you're generally going to be okay. To speak a little bit more about that, absolute novelty is the standard. So as soon as somebody else knows about it, it's no longer an invention. As I mentioned, it's any publication, any sort of public disclosure. The US used to have a 1-year grace period, and there's a lot of people who look online and you'll still see web pages that say that. There was a round of amendments to the statutes by the US Congress called the American Invents Act a number of years ago, and they tweaked the rules on what that grace period entails. And they cut it back significantly. They didn't completely get rid of it, but there are a lot of limitations that are on there that used to not be there. And so I generally just summarize this as you should just assume that you're not going to have access to that grace period, and you should just assume that the US, like the rest of the world, requires absolute novelty. Once someone else knows about it, it's no longer a patentable invention. For a lot of companies, this basically means that they like to have some sort of approval process before any form of public disclosure occurs. And the public disclosure is not only sort of scientific talks and things like that, but can also include commercial partners, offers for sale, publications, joint development agreements, suppliers, vendors, contractors, etc. And so any of this sort of thing before any information gets released to any of these entities, most companies will have some form of approval process to make sure that any sort of patent protection has been thought about it and a decision has been made before this information gets out there. So legally, what is a patent? As I mentioned, it creates exclusionary rights. So it's this right to keep other people from doing things. It's basically a government bargain with the government. You have to disclose to the government certain things, and in return, the government grants you certain types of rights. So what you have to disclose to the government, and this is a sort of a summary, you have to disclose what your invention is, which is called the specification. You have to request some level of protection, which is what are called the claims. And it has to be a government office that processes this information. And so most governments have a patent office that deals with this sort of thing. You file your application with the government office. A bunch of processing occurs. There's usually some negotiation as to what the right scope of claim of protection that you should get is. And in the end, you get out the other end a patent, which is a grant of rights. Now the patent itself, in some form is really just a stack of paper that has some legal rights attached to it. It doesn't really do anything by itself. There's no patent police. The government itself does not enforce patents that issue. Those are left to the people who own the patent. And so that also means that once your patent issues, you have to see who else is out there that might be doing things. And if they're doing something you don't like, you have to go back to the government and you can ask the government to make them stop doing that sort of thing. Again, it's that exclusionary right. The mechanism for doing that is the patent infringement lawsuit. So you have to file a patent infringement lawsuit with the government. You're suing the other side for infringing your patent. And it's the power of the government that ultimately causes that entity to stop doing whatever it is they're doing. Usually it's a court order issued by the judge or the court in that case. And so you see, it's really the government that has this power. And it's not something that just sort of exists by itself. It's a bargain with the government. At the end of the process, so your patent has a limited lifespan. Once the patent has expired, you no longer have any rights in that patent. It's not part of the public domain, and in that way, the information that was in that patent application now becomes part of the public domain, and that's how knowledge is advanced, in society. So if you think about it, the value of the patent really is in its enforcement, and often it's the potential enforcement rather than actual enforcement. A lot of companies don't really want to go into a patent lawsuit against someone else. It's expensive, it takes a lot of time, it's not very pleasant, it creates problems with publicity and things like that. And oftentimes, most patent actions don't make it all the way to a trial. It's really, you threaten the other side for trial, they threaten you to take you to trial, and you end up settling and coming to some sort of negotiated agreement where everybody gets something and you're not fighting a lawsuit. So very few of them actually get all the way to a lawsuit, but the value is the fact that you could do that, and you'd rather not do that. So when we start talking about international patents and things like that, as I said, this is really government action. And so it's only as powerful as the government that you have. So if you have certain courts, like you have an American court, its jurisdiction is America. So it stops at the borders of America. So if they're doing this action in another country, such as Mexico, for example, you can't go to Mexico with a US patent because the Mexican courts won't recognize the US patent or the US jurisdiction. You would have to go to a Mexican court with a Mexican patent. And since there's a lot of countries in the world and each country has their own patent system, that's where it can get rather complicated because you have to file patents in each country. This is something that can get very complicated, as I said. There's a lot of issues in terms of things like translation, time zones, when you have to file. A lot of countries require you to get what's called a foreign filing license, which basically means before you can go to another country's patent office, you first have to get permission from your country's patent office in order to do that. So it's a very complicated system that requires a certain level of coordination between all these different countries. And usually, you would hire a patent lawyer to help you navigate this process. To make things a little bit simpler, a number of countries around the world, most of them actually, have signed what's called the Paris Convention, which allows some degree of coordination. So rather than immediately having to go to each country when you want a patent, you need to initially file one application in your home country. In the US, this is often referred to as a provisional application. And that gives you sort of 1 year to determine whether you actually want to go through this process and file the patents in all these other countries. And if you do, the date that you're given is basically the date that your application was initially filed in your home country. So this helps to eliminate this problem of, well, different countries around the world are in different time zones and have different requirements and so forth. This allows you to just initially do one application in your own country, and that preserves your right to go into all these other countries within 1 year. Subsequent to the Paris Convention, there's another treaty that many countries around the world signed that's known as the Patent Cooperation Treaty. And this created a common subsequent patent application that helped streamline the process a little bit further. So at the 1 year date, instead of having to file in all these different countries, you now have to file what's called an international or PCT application. And this gives you a little bit more time before you have to decide which countries to go into. And the agreement actually specifies for at least 30 months. Some countries have given 31 or 32 months. And that gets added on top of the 1 year date from the provisional. So if you file your first case, you have up to 12 months from there. And then once you've filed this PCT application, that will give you an additional 18 months. So 12 plus 18, that gives you 30 months to make a decision as to which countries you want to go into with your application. During this PCT application, you'll even get an initial review by an examiner. It's non-binding, but it sort of gives you a little bit more information as to, gee, do you really want to go into all these countries, or is this something that, an examiner's finding a lot of prior art, and it looks like that you don't really have an invention here because a lot of other people have thought of the same thing, and then maybe you don't want to spend all this money and time going to these different countries. One thing to keep in mind is that the PCT application is not a patent. It can never become a patent. It's really only an option that allows you to go foreign file in all these different countries. And its real mechanism is to delay costs, give you a little bit of information, and help slow down prosecution until, as I said, at least 30 months from first filing. On the right here is an example of what a typical PCT application looks like. It will usually have a thing that says PCT at the bottom of it. A lot of people will read these things and assume they're actually patents. They're not. They're an option agreement, if you want to think of it that way. And then at the end of this process, it goes into different countries. You generally have to apply country by country. So if you want to go in the US, you have to file in the US. If you want to go into Canada, you have to file in Canada. There's a few jurisdictions that have a multi-country system. Europe is the most prominent example. So you file your PCT application into European Patent Office, and then that gives you the right to pursue the different countries within Europe at a later date. So if you're interested in UK, France, and Germany, you don't have to decide that right away. You can just file the European case and decide those later. The PCT itself is a international treaty by various governments. not all the countries around the world have signed this treaty, and so those countries, so many of them have signed the Paris Convention, but not the PCT, which means you have 1 year, but then you have to go directly into the country, and you can't use the PCT application to get there. The most prominent countries are Argentina and Taiwan that are not signatories to the PCT. As you can imagine, there's a lot of rules here. There's a lot of translation, filing fees. You have to get foreign attorneys involved. And it's something that very few people would like to do by themselves. Most people would hire a patent attorney to help them navigate this process. One other thing to keep in mind is that the PCT application itself cannot be amended. And so one issue that can happen there is that if you file an application as a PCT and then you come up with subsequent improvements, you can't go back and fix the PCT application. This also can create a lot of issues because, as I said, different countries have different rules on what they want to see in a patent application. And once you file your PCT application, this PCT application has to comply with all of the foreign laws of all the countries that you care about. And oftentimes there's a lot of different issues that each country has, and all those issues have to be thought of ahead of time and written into the PCT application, because if you don't, then you can't go back and change it. So a lot of these drafting errors and country-specific things are things that you need to make sure are written in the original PCT application, before you get to these stages. Another common danger that I often see is that keeping in mind what the time zones are. So most filing deadlines are determined locally. So when people do the count of 30 months, for example, they're doing it as of local time. They're not doing it as the time it was filed. So if the U.S. application we're talking about, and then you want to file it in Japan, the real deadline isn't necessarily 30 months. It's really 30 months minus 1 day, because Japan is 12, 13 hours ahead of the US. So you have to take that into account. So I've seen a number of cases where people, miscounted that because they forgot that Japan's a day ahead of us almost. But assuming you're keeping an eye on the calendar, your typical national entry of the PCT case occurs at about 30 months after your first filing. Sometimes it's 31 or 32 months. At that point, you have to comply with each country's requirements that you're entering your case in. Oftentimes there's a number of things. There's a number of documents you have to sign, powers of attorney, filing fees. Many countries will require you to file a translation of the application, but they'll often give you a few extra months to do that. So if you file your PCT application, say it's written in English, and then you want to file it in China, you can file it in English, and then you get a few extra weeks to file a Chinese translation of it. Some places, for example, if you're filing in various South American countries, you can use a Spanish translation for more than one country. Other countries such as China or Korea, you have to translate in Chinese or Korean, and so that can get very expensive very quickly if you're looking at a number of different countries. Another thing that you often have to do is file a request for examination. Some countries will accept your application, and then until you ask them to pick it up and give it to an examiner, it'll just sit there. Sometimes that's a good thing because you're not really sure how interested you are in that country, and you'd like a little bit more time to figure that out. And other times, you want prosecution to get going immediately, so you might file a request for examination as you're filing the application itself. Another thing that happens is that because there's a number of different countries and they all have their own different patent laws, usually most patent attorneys won't handle these countries themselves. They'll work with a foreign associate or somebody who's in that country to help with the laws and the translations and coordination with the local patent office and so forth. These can vary widely in price and quality, and it's an area that many people overlook. Some foreign associates have strengths in particular areas. Some of them are good in various technological areas, so biotech or computers or something like that. Others might be better at appeals and other patent procedures that can occur. Personally, I found that the best foreign associates are the ones that will offer independent advice. They see themselves as a partner. They'll give you suggestions on what to do with the local patent laws and how you navigate their local patent office. There's other ones that will basically act as a mere vending machine. They'll do whatever you ask them to do. But since they don't push back or give you any independent advice, I sort of feel like I'm talking to a vending machine, and it can be problematic if you're not getting the right kind of counsel from them in terms of how to navigate the local patent office. If you're working with a law firm, they often will select their foreign associates, but it's something you can override, and it's often worthwhile asking them a couple of questions about who's going to be handling your case in each of these countries, and why do you trust them, and are they really the right people to do the job? Do they have the right technical background? Do they have the right legal background? If you have a question about the local patent office, can you talk to them directly? Those sort of things. And it's important to stay involved in the process and not assume that the law firm has selected the right foreign associate to help in this work. So the next part of this talk is just to say some of the more common mistakes I've seen when foreign filing cases. One of the most common ones that I've seen is that the initial application is drafted specifically for a particular country. There's a lot of differences in how patent law is interpreted around the world. European law tends to be rather restrictive. The US tends to be a lot more loose in terms of what it will allow. Japan, for example, can require a lot of experimental evidence in the application, whereas other countries don't require as much. Some types of claims don't exist everywhere. And so there's different nuances that different countries will require. And if you're not aware of those, or your patent attorney is not aware of those, they might be missing out on things that are important to be putting into the application for each of these countries. Related to that is just not consulting with foreign counsel on strategy, both when you write the application and when you're prosecuting the application. You assume that the law in one country works the same as in other countries. A classic example of that is obviousness law. It's very different between different countries and how they interpret it and what they think is a sufficient advance of something to be worthy of a patent. And the way they detect the problem, how they analyze it is very different. Another mistake, and this is something that a lot of people overlook, is how expensive all of these things can get. In addition to the cost of preparing the application, each country has various fees that are associated with either maintaining the application or for filing divisionals or continuations, which are sort of add-on applications to go after additional claims. Some countries like Europe will charge a yearly fee. It's basically a tax that you have to pay this tax to the government if you want your patent to stay pending in front of the patent office. And it's a couple $100s a year, but then that starts adding up, and over time they also increase the fees. So if you have a number of cases in Europe, these can add up to several thousands or tens of thousands of dollars, where it's just pure tax. There's not even any prosecution. You have to pay this tax if you want to keep these cases going. And if you're not budgeting for the thousands or tens of thousands of dollars, this can come in as a bit of an unwelcome surprise. As I mentioned before, another problem that often occurs is the failure to account for time zones. Places in the Far East, Australia, Japan, China, they're at least one business day ahead of us. Australia is something like 13 hours ahead of New York, and 17 hours ahead of Los Angeles. So if you're not taking that into account, you might be missing deadlines because they're actually a day ahead of the US. Another common mistake is that if you have a bunch of countries with the same application that's pending in them, things that you say in one country can be used against you in another country. You can't say that A is equal to B in one country and say A is different than B in another country, because examiners will start saying, well, you're being inconsistent with yourself, so I don't believe you. That can create a lot of problems. And finally, a number of these countries have these various multilateral patent agreements. The most common one is something known as the PPH, for Patent Prosecution Highway. Essentially, it allows the results of one country, the patent searching of one country, to be used in another country. And so there's some advantage of being able to do this because it helps streamline some of the prosecution. That's why it's called a highway. And it can be advantageous to getting patents to issue quickly in multiple jurisdictions, and a lot of people aren't even aware of these agreements, or are taking advantage of them to try to get patents through various countries more quickly. One other common pitfall that often occurs is not understanding the difference between patentability and infringement. These are actually two different things, but a lot of people get them very confused. So patentability is basically the question of, is my company's invention deserving of a patent? I have a new invention, does these great and wonderful things. Can I get a patent on it? It's defined by the claims. It has to be a new thing, as we discussed before. It's something you go to the patent offices and if you can convince the patent office that you do have something new, they'll issue you your government document called a patent, and you have this ticket to be able to go to court and stop people for infringement. Now, remember, patentability and patents in general allow you the right to stop other people from doing things. It doesn't necessarily mean you have the right to do that thing yourself. The question for that is an infringement question. If I develop and sell a product or a process, will I be blocked by a claim of someone else's patent? Now, this question is dependent on the product or process. If you're not selling any product or process, you might still be inventing things, but since you're not selling anything, you're not worried about infringement. And in fact, most universities, for example, are sort of falling into this category. They may be inventing a lot of things, but they're not really selling a lot of products. They're in the business of furthering scientific advancement, not in selling product and making money off those products. Conversely, you can be selling a product, you might not have a patent on it, but that doesn't make you immune to being sued for infringement. And that's true even if you have your own patents that cover these products or processes. It's really defined by what claims someone else has, and do those claims cover what you're doing. And the thing that you're selling might have some novel things on it that allows you to have a patent, but it might also have other things that are covered in somebody else's patent, and therefore they can sue you for patent infringement. And it's not a defense to say, well, I have my own patent that protects these ideas. So this is evaluated generally through a freedom to operate study by a patent lawyer, and it's ultimately something that's determined by litigation in the courts, not by the patent office, and it's someone else's right to stop you. So just a couple of other thoughts before we close the presentation. The whole point of a patent really is to exclude competitors. And so if you think about it, it's really not enough just to say, well, here's the thing I invented and here's a description of what I invented. What you really need to do is describe what are all the things I want to stop my competitors from doing once they learn about the thing that I invented. So this includes a lot of obvious extensions to the technology. So if there's a particular way you found that something works, it might not be the only thing that can work in that way. There might be other ways of getting to the same idea. And those are things that you need to describe in your patent application, because those are things that somebody else is going to try, and it's going to be something that you'd want to stop them from doing. To do this well, it often requires some sort of situational awareness about what your competitors are doing. What are the things that they might likely try once they learn about what you're up to? What are the things that they might do to start going into the market spaces that you care about? Can you do things to stop them? Can they do things to stop you? What are things you can build in that application that will give you this level of protection to keep competitors, out of these spaces? As you can guess, this requires a fair amount of strategic planning. It's not enough to say, well, I'm going to do all this work and then I'll just give it to my patent lawyer, expect them to sign their name on it and file it. A lot of this requires a great deal of strategic planning, understanding not only what your invention is, but what your business goals are and what new improvements might come out of these ideas that you have. You often won't know exactly what to protect until later because your competitors won't know about this right away, and by the time they get going, it'll be some time that passes, and by then you want to have your patent application on file. So it requires a lot of guesswork and hypothesizing and understanding where everybody is and where everybody's likely to be 6 months, 1 year, 2 years down the road. Because of this is the reason why a lot of investors will ask questions about patents. It's not just investors, but also partners, co-development agreements, things like that. Business strategies often change. You need some level of flexibility to pursue these different ideas. And these are all things you have to do, from the beginning, because there are things that are impossible to fix later. A lot of investors will ask about your patent position, and it's not because they want to read the patents. It's really because they're interested in protecting the investment or the partnership arrangement or what have you. And so if these aren't done the right way, they can create a lot of problems. They want to attract investments or partnerships. And I generally tell people at the end of the day, it's like everything else, you get what you pay for. So there's a few takeaways. Remember that patents really are business tools more than anything else. Their goal is to create barriers of entry for competitors. It's not a commodity where you just simply describe what you invent, but it's a tool that's being used to protect partnerships and investments and things like that. There's a lot of technical and legal requirements, especially when you're looking at international filings and trying to get patent protection in different jurisdictions around the world. So it's important to hire a good patent lawyer who understands both the science and the law and also the business environment that you're in. And as I said, if you don't remember anything else from this talk, remember that you should talk to a patent lawyer before you publicly disclose anything to anyone. If you have any questions, be happy to answer them. And here's my contact information. Thanks for listening to my talk.
Okay, thank you, Tani. Thank you for that informative presentation. We do have a few questions. The first one, how would I know if someone is infringing on my patents?
It's a good question because there's no patent police. There's no government agency that's going to tell you that, hey, someone's infringing your patent. It's something that you have to do yourself. There's a number of ways to get this level of information. A lot of it can be just sort of reading the news or going to trade shows, talking to people, that sort of thing. Looking to see what your competitors are selling, looking at their websites or brochures that they're producing and things like that. So it requires a fair amount of detective work and situational awareness to be aware of what your competitors are up to, and then if there's something that doesn't look right, to start asking questions and involving patent counsel to see whether maybe they're doing something that looks like infringement.
Okay, and what are some different methods for monitoring for that?
Number of different things. As I said, there's a lot of it really just involves keeping tabs on your competitors. There's a number of clients that I have, for example, where we do a regularly scheduled monthly IP search of what patents that they're filing and what applications they're filing and keeping an eye on those. And most of the time we see them and they're like, well, that's an interesting application, but it's not really relevant. But occasionally you'll look at something like, well, this looks very important. We need to figure out what they're up to. Same thing when we have the clients and they have employees that go to trade shows and stuff like that. We always ask them to go and look at what the other tables and look at what the competitors are doing and what they're trying to sell and get information that way. So it can come in through a number of different channels.
Okay, and can I hire someone to monitor for patent infringement?
You can. Like I said, we do a number of searches for various clients on their competitor patents and keeping an eye on them. So one opportunity is your patent lawyer. But another great resource is just the employees you have that work for you, and they're often in touch with colleagues and that they went to school with that are in competing companies or people they've met at trade shows and things like that. Just asking them to let anytime they learn some new piece of information and having that information come into into the company.
Okay. All right. The next question is a scenario where the person said, I'm in a team in Spain that has partnered with other international teams in the US and Germany, and together we have created an invention. Before filing the PCT application, should we choose a particular country like Spain, the US, or Germany to file the first patent? Is there a best country to file this first patent in?
Yeah, it's a good question because often it's not really a question of the best country, it's a question of which countries are even allowed to file in. So most countries require you to file the first application in that particular country, and of course if you're have a multinational team of some sort, right, then you've sort of got two answers and neither of which you actually have permission to do because of the other country. So you have to pick a country, and then the other country you have to get a foreign filing license that allows you to first file in the other country. The US has an expedited procedure, most other countries do as well, where you file a request to be given permission to first file in that country. So for example, if you have a US team and a Spanish team, depending on which country you decide, you might decide to go to the US patent office and request a foreign filing license so you can file in Spain, or you can do it the other way around. You could go to the Spanish patent office and request a foreign filing license to first file in the US. That part doesn't matter quite as much as just making sure that the application itself is drafted to be able to go into prosecution in both of those countries. Whichever country is the first country and you get those permissions, you'd file the application in, then it'd become a PCT, and then you'd have rights to pursue, the application in either or both of those countries. But it's that initial application that hopefully has the right language in it so that it will support, strong European claims and strong US claims.
Okay. The next question, when is the best time to file an international patent, considering the fact that I'm not sure if I will use the invention internationally?
Oftentimes it becomes a commercial or a business question. The minimum requirement is that 1-year deadline that I talked about. So once you file your first case, in the US or in whatever country you're in, you have that 1-year deadline in which to make this decision. You can file sooner. I've had cases where people are like, well, we immediately know that we want to file this everywhere. We're not even going to bother waiting the 1 year. And the first application to file is the PCT, and then they have 30 months to make that decision. More often than not, though, there's usually some level of uncertainty, and then people will wait some time. Sometimes it's not only 1 year, sometimes it's 10 months or 6 months or what have you. That is really more of a deadline, and and if you have if the business decision is yes, we need this going more quickly, there's nothing to stop you from doing that.
Okay. The next question, if I file patents in several countries, but the person or organization caught infringing on my patent is located in a different country, what enforcement tools are available in such a case? Is there any international organization that can enforce patents?
Right. Yeah. Unfortunately, there's no international organization that does these. As I said, most patents are jurisdictional, which means that they're only going to be enforceable in those countries. But it also includes, like in the U.S., for example, the language is making, using, selling, offering to sell, or importing. So the importing part becomes important because the U.S. courts have jurisdiction on anything on U.S. soil. So if it was made in a different country, say it was made in Pakistan and then shipped to the U.S. and you don't have a Pakistani patent, well, the instant it crosses the border, you can stop it at that point because once it crosses the U.S. border, the U.S. courts have jurisdiction and they can keep it from entering the U.S. So even if you don't have a Pakistani patent, you might still have some ability to keep them out of a market that's important to you, such as the U.S. If they make it in Pakistan and sell it in Pakistan, right, then you don't really have a lot of recourse with your U.S. patents. But that's often why people will focus mainly on the key jurisdictions, basically the ones with the biggest economies, rather than trying to file in all 100 plus countries around the world because that's just too expensive. So the key ones that almost everybody discusses are the U.S., Europe, China, and Japan. Those being the ones with the 4 largest economies, in the world.
Okay, thank you. The next question, if the patent application should include future foreseeable developments, if I include all such uses, do I risk making my patent application too broad? How do I find the right balance?
Potentially, it's something that you need to work with a good patent lawyer on to help you understand what the right balance is, because at some point, if you push it to its logical extreme, everything becomes a speculation, which is probably too much. But if you don't do enough of that, then really obvious sort of tweaks to it would be things that somebody could get away with. And so finding that right balance is important, and it's something that's sort of difficult to explain without understanding the technology. In some areas such as mechanical things, you can predict pretty far in advance what people are going to do, and it's very likely to work because mechanical things are things that people have a pretty good understanding of. On the other hand, if you're talking about a very cutting-edge area of biotechnology, you move a couple of atoms around and you've got a completely different molecule, and it gets very difficult to predict how many tweaks you can do before it gets too speculative for people to feel comfortable with. And so it's a question that's worth asking a patent lawyer as you're developing a patent strategy.
Okay. The next question is, could you provide examples of how a badly written patent could have an adverse effect on a company's ability to maximize the value of its invention.
Yeah. Well, a number of years ago, which is an interesting story, is I was asked by a startup company to look at this patent that they had filed by another entity. It turns out that it was filed by somebody who wasn't even a patent lawyer. It was actually somebody who was a tax lawyer. Thought it'd be a cute idea to write a patent in his spare time, and he wrote this thing, and filed it as a patent attorney. It was his very first patent application he ever drafted. Apparently had nobody telling him, how to do these sort of things. And so this company asked me for a second look on it. And I basically said what I just said here. It wasn't something that I thought was very valuable or interesting. I know the company was shopping around desperately to get investments to get this company off the ground. Talked to a number of different companies, and they all basically said the same thing, which is that we don't think that this is going to support any investment in that we would give you. We don't trust you to protect our money and develop this as a reasonable product. Anything that you develop, this patent is useless. It's going to get ripped off. We're not going to trust you with our money. After about 2 years of this, the company basically folded. It was a great idea. I love the idea, but they could not get a single investor to give them any money and do anything with it because this patent application was just so poorly drafted, and it basically ended up killing the company. Obviously that's a bit of an extreme story, but I have seen that happen at least twice.
Okay, thank you. Are there any other questions for the presenter? Okay, I don't see any other questions. Thank you for presenting today, Tani. We really appreciate you taking the time to share your expertise. Please watch our website for future planned webinars at actionNewEngland.org. And thank you everyone for joining us today. We hope you found this informative. Thank you and have a great day.
Michael left, so I think.
Yeah, I guess we're done recording. Yeah.
That should mean that, yeah, we can leave the meeting.
Yep.
So, well, thank you, Tani. It was great, very informative.
Thanks.
Okay.
Yeah, hopefully the recording went well this time around.
Yeah.
Let me know if we need to do something else, but hopefully this worked.
Yeah, it worked perfectly. So yeah, we'll let you know how everything went. Thank you.
All right, thank you.
Bye-bye.
All right, bye-bye.